Hello, and welcome to the video lecture on Chapter 9, the American Legal System and Courts. So we're going to review the class notes, text points, essay questions, announcements. We have discussion board 9 and assignment 8. What we'll learn about, learning objectives. Another slide on the learning objectives. Essay number 4 will be on same-sex marriage. When the text was written, Ohio had passed a constitutional amendment banning same-sex marriage. That was overturned in Obergefell v. Hodges 2015. Also, Ohio has decided to legalize marijuana. We're in the process of doing it now. The law has already taken effect, and the procedures are being put in place this year for full implementation by September. Assignment number 7 is a Supreme Court case affecting Ohio. In the name Golden Week will be used. So here we go. What is the role of law and courts in our society, particularly a democratic society? It's the neutral third party that helps us resolve conflicts, provides security, predictability, a real conformity, a safe playing field, allocates rewards, benefits fairly. The American legal system, number 46, is really made up of two things: common law, which is law based upon the accumulated judicial rulings over time, sometimes called judge-made law, and then civil law, the law that is written by legislators and codified or written down over time. Precedent, number 48, is often called stare decisis, or let the decision stand, and precedent is using a previous decision to bind future decisions. Judicial review, that is the court's power to determine the constitutionality of a law, which is a very powerful source of power in the United States. Not all countries have the judicial review the way we do. Substantive due process is the content of the law. Actus rei and mens rea, the guilty mind, the guilty act, actus rei, and the guilty mind. Procedural due process, number 49, please define procedural due process. Those are the laws that protect individuals as they're in the legal process, whether that's the civil or the criminal process. What types of law do we have? That's number 50. What is the difference between civil and criminal? Well, the civil law system are acts that are harmful to another individual or a group of individuals or an organization. Those are called torts. When there are acts that are harmful to society at large, we would call that a crime. So something can be both a crime and a tort. If you were to commit a crime against someone, let's say that you assaulted someone, you could be arrested for the harm that that does to society, your lawlessness, and put in prison. At the same time, you can also be sued and your resources are taken in a civil court because that is a tort. You did something to another individual and they might ask for money for that or reparations or their family should something happen to that person. So constitutional law is the highest of the law that we study. Constitutional law are those cases that arise from the Constitution or the body of law that surrounds it. So some of the law we'll talk about in this chapter is constitutional law. Common law, again, I said before, laws based on judicial tradition and the body of cases around it. A very classic common law is two people that cohabitate for 7 years or more. Whether they like it or not, they're married. That's a common law marriage, it's called. And whether they go down to the courthouse or not does not matter. Should that situation, domesticity, break up, they would be subject pretty well to the same laws as divorce. Statutory law, those are, again, like the civil law, the codified law, laws from legislatures, both U.S., Congress, and the state. Administrative laws, number 52. Those are laws from bureaucracies on behalf of Congress. That's the president's executing arm of the law, departments and agencies. Executive order. Oh, and I want to go back 52. Can Congress pass an administrative law? And the answer is no. Administrative law, by definition, is written by an agency. So the Federal Aviation Administration that has codified after 9/11 that you have to show your official ID to be able to fly. And that the name on the ticket must match the official ID. That's an administrative law. Congress doesn't do that. It's FAA did that. Executive orders, we had that controversy in the presidency chapter. Those are clarifications of executive policy issued by presidents and then governors as well. The structure of the U.S. court system, well, the federal court system has three levels: a district court, which is a trier of fact where actual crimes and other things are heard; the Circuit Court of Appeals, which is a smaller group of courts that cover a territory. That's why it's called circuit. In the old days, you would get on your horse and ride the circuit, as they say. And then finally, the U.S. Supreme Court. The state court structure is pretty well all the same. They have trial courts, and then an appellate court, and then a state Supreme Court. So our systems are pretty parallel. A few states, a little smaller ones, don't have the mid level appeals court like New Hampshire. So here's the state district courts, their court of appeals, their state Supreme Court, the U.S. District Court, Court of Appeals, and then up to the Supreme Court. As you can see, cases can come to the Supreme Court actually from three directions. They can come from the Court of Appeals up through the federal system. They can come over the state Supreme Court, and there are a very few cases that are original jurisdiction directly to the Supreme Court. That would be the case of a dispute of a boundary line between two states, like Ohio and Kentucky. Where's the sign on the Ohio River? Where is that? By the way, Kentucky has about 80% of the Ohio River. That's where the sign is, by the way. Understanding jurisdiction. So things that determine jurisdiction are things like where was the crime committed? So committing a crime in one state, you can't then drag the person to another state. What law was specifically infringed upon? Who committed that law? Actual citizen, non-citizen. What was the nature of the offense? So the who, what, where, the nature, these are parts of jurisdiction. Judicial review, uh, number 54, is the power to really look at a law and the power to declare it unconstitutional. I said before, I would longer thing that we don't have time for here, but it's Marbury v. Madison, 1803 is the court case that did it. It's been used very infrequently. It was only used one time in Marbury before 1857. And judicial review is not mentioned in the Constitution. It was something that the court declared power unto itself. Courts with original jurisdiction, the U.S. District Court state trials, and again, very rarely a Supreme Court will have it. Courts with appellate jurisdiction, they're courts that hear courts from the original or trier of fact, as it's called. Typically, the Court of Appeals, one layer up, just looks things over, makes sure it's okay. And then courts with both original and appellate, the U.S. Supreme Court. So the U.S. District Court, the lowest level, there's 94 districts. There's one in Cleveland. So each state has at least one. And they hear both civil and criminal cases, and juries can be used for their verdicts. The Court of Appeals, so the country is divided into 12 circuits, solely appellate. So they're not retrying a case that would be done at the lower level. They are not looking at new evidences or new witnesses. It's a panel of three, and they make a ruling. It's lawyers talking to lawyers, and then judges make decisions. The selection of judges methods vary. You can appoint, you can elect without a party label, nonpartisan, or elect with a party label. Some states have even used a ranking system or some type of system, merit system, I think it's called. Federal judges, they're all nominated by the president and confirmed by the Senate, and senatorial courtesy is used. I covered that in a previous point. So again, in the state of Ohio, a federal appointee, Rob Portman, would now be involved since Donald Trump. Federalists believed in a strong independent judiciary to keep the power of the factions, those interest groups, from getting powerful. They felt the Supreme Court was the least dangerous of the branches. I think people sometimes feel because the members of the court are unelected and serve for life that they can be sometimes the most dangerous. And they point to decisions like Roe v. Wade. Whether you agree with it or disagree with it, the whole point is it's a very powerful decision. The Supreme Court has 9 members, by the way, currently only 8. Justice Scalia passed away in February of 2016. A Republican Senate had no intention of taking any of the nominees from President Obama, so we'll see if we get us back tonight. They serve for life. Key characteristics of the Supreme Court. They wait for cases to come to them. They don't actively support them out, and they don't deal with hypotheticals. The Supreme Court gets about 10,000 petitions a year, and it really only looks at 1 or 2%. It hears about 70 or 80 arguments, oral arguments, and makes about 150 decisions. You can look at the Supreme Court website for the biographies of the justices. What makes number 54, judicial review, so controversial? And I think it is in the United States because it really has made the court a much more powerful branch, and I've already went over some of the factors involved with that. Marbury v. Madison was the first case that established judicial review, and maybe I'll talk a little bit more when we get a chance to be face to face on that. The Supreme Court and how it makes decisions. So there's a judicial calendar. They hear cases starting in October, work their way through about 5 or 6 months, and they take a break. They will hear a case based upon a writ of certiorari. So that's the writ of certiorari, number 47, is a petition by someone who lost a case at the lower level for the Supreme Court to take their case on appeal. And it takes the rule of four. It takes four votes. Of the justices have to put their hands up informally, and when they sit around the table, to actually decide whether to hear a case or not. Amicus curiae, number 59. The amicus curiae is the friend of the court. It's a brief written to try to influence the court to hear or decide a case in a certain way. There's a case I will talk about when we get together, Gideon v. Wainwright, which created the public defender system. And in the case of Gideon, a handwritten petition from someone sitting in a Florida petition went to the Supreme Court. But it also had 22 states that filed amicus curiae briefs that said, please, please, please hear this case. That was very influential for the court hearing it, and ultimately the decision of the court in Clarence Earl Gideon's favor. So the court hears oral hearings. They're timed. They can interrupt you. It's a terrifying experience. There is judicial restraint. The judges decide what is in front of them. They don't decide further than that if they can help it. Then the Supreme Court meets, discusses, and decides behind closed doors. In fact, so closed that the most junior member of the court actually literally is the one who answers the door and brings the food in and out. Then the courts gather. Once they make their decision, a majority then gathers to write an opinion, and then they announce that opinion weeks and sometimes months after they've heard the argument. The opinion of the five or more justices is called the majority opinion. You might agree with the Supreme Court decision in direction, but not maybe all the reasons. You want to add something to it. That's called a concurring decision. You might agree for a different reason. And then dissenting, which is number 60, it says, what is the significance in common law and court law of dissenting opinions? And the reality is that what is law today might be different tomorrow. So, separate but equal in Plessy, 1896 was the law of the land, but there were many justices that said over a period of 50 years that separate but equal is not so equal. And eventually, in Brown v. Board, 1954, those dissenting voices were heard, and the Supreme Court banned, desegregated the school systems of the United States. So today's dissent could be tomorrow's law of the land. So here are the justices, the 8 of them. So 4 liberals, and then I would say 3 conservatives and a moderate. Scalia was a conservative, so there actually was 4, 4, and 1 had been the kind of layout of the court. So we'll see where the appointments are. I want to go back here and look. If you look at it, Ruth Bader Ginsburg is probably the 83 there, I think. People are thinking maybe she would be the next one to kind of step out. And look at Anthony Kennedy. Look at the dates here: 91, 06, 06, 88. 93, 2009, 94, and 2010. So 1988, Anthony Kennedy is the longest lasting one. He was appointed, think about this, appointed by President Ronald Reagan, and he is the oldest justice at 80. So what influences Supreme Court decisions? Every decision presents the justices with an ability to say something that is looked at, analyzed, and can be used for later purposes. So it's very important stuff. So, there's a 60-minute interview with Justice Scalia, who passed away. So judicial activism, when the court kind of asked to do things, so if they say, hey, you need to bus, you're going to bus students from point A to point B, people scream and yell, oh, that's judicial activism. Number 58 asks, why has judicial activism become an important political issue? Because conservatives feel, and the conservative liberal agenda, conservatives feel that judges are creating their own law. They're being basically legislators by making judicial decisions. They are unelected legislators who serve for life. and maybe liberals feel that judges are really the protecting the little guy in the system, so it's okay for them to step out every now and then and do those things. So that's particularly why. Strict constructionalism is about, and again, conservatives tend to fall into that group. Strict constructionalism, number 56. That is one of the ways to look at the Constitution. It means it should be read literally, keeping the framer intent in mind. And that if you don't feel that way, the flip side is judicial activism. So it's strict constructionalism or judicial activism are kind of the two ways to look at it. That's what I've got for this particular chapter, and I hope you enjoyed it. We'll talk a little bit more in class, probably look at Gideon v. Wainwright and the current makeup of the Supreme Court, and talk a little bit about who and how maybe a nominee will come forward.